Good morning. This is Francesco Barbera with Barbera Corporate Law, and I'm here with my former colleague, Dawn Irizarry, who's now with the firm of, let me make sure to get this right, Carothers DiSante Freudenberger. They're an employment firm with, and Dawn is based in their LA office. Dawn and I used to work together at my former firm, Proskauer Rose, and she's been practicing employment law for a real long time. And in a minute, Dawn, I'll just ask you to share a bit more about your professional background. And the topic of this conversation is going to be a decision and an event that in the life of a lot of entrepreneurs, many of my clients, is most unpleasant, difficult, stressful, and that is letting an employee go. And in particular, we're going to ask for Dawn's wisdom and counsel on how to do that in a way that mitigates the risk, creates the least amount of friction, and essentially how to do it well as possible in that context to protect the business and in all respects, legal and otherwise. So with that brief intro, Dawn, if you could share, oh no, are you still with us? Okay, good. I thought we lost you there. It's always adventures in teleconferencing. It's always an unknown how it'll go from a technology standpoint. So in any event, Dawn, if you could share a little bit more with our viewers and listeners about your professional background and your current practice and how you help companies and entrepreneurs, that would be a great starting point, and then we'll launch into our topic.
Okay, thank you, Francesco. As you indicated, you and I worked together at Proskauer. I spent the first 8.5, 9 years of my career with Proskauer Rose, where I resided in their LA office and their New York office for a period of 2 years. I am barred in the state of California. I did obtain my license to practice in New York, although I have not practiced in the state of New York for many, many years now. I have devoted my entire career to employment defense work. I have been with Carothers DiSante Freudenberger, and I will hereinafter refer to them as CDF. Keep things simple. I have been with the firm since January of 2012. We have 5 offices throughout the state of California, 2 in Northern California, Sacramento and San Francisco, 3 in Southern California, Los Angeles, Orange County, and San Diego. And our firm is devoted to defending employers in all types of labor and employment claims, and we also do immigration work. Currently, I have a large number of clients, big and small, many in the healthcare industry, some in retail, some in sports, property management, you name it. We handle all types of matters for clients of varying sizes. And so whether an employer is terminating an employee or being sued for that termination, we advise our clients throughout that process and handle any litigations that result. And so our goal always is to ensure that we're giving them the right advice so that they don't get sued. But in the state of California, as everyone is well aware, it's virtually impossible to ensure that an employer will never get sued for an employment-related claim because the laws in California are very protective of employees. And in some cases, they're just confusing for employers to get right. So our job is to help mitigate that confusion and provide some clarity, and then to handle any litigations that may be.
Terrific. That's really helpful. And so do you counsel on the sort of employment policies end of things, handbooks, and establishing employment policies and that sort of counseling side of things, as well as the litigation, prevention, and representation?
Correct. We have all of our attorneys, myself included, regularly counsel employers in terms of policies. The laws in the state of California are constantly evolving and changing, and so that results in changes to policies. I think California sick leave laws is one prime example where certain counties within the state of California have different sick leave laws or mandatory sick leave laws from the actual California state sick leave laws. So it's really important for employers to have counsel to know which laws apply to them in their venue to ensure that they get it right. And it's very difficult for any employer, frankly, to keep up on that. And so one of the things that I would just say kind of at the outset is if you are listening to this, it's because you are doing business in California and you have some concerns about this issue, you should probably sign up for our blog, because we regularly send out blog alerts regarding any changes to the law in the state of California. It's one of the most highly rated blogs in the state of California for employment work, and it's very informative. And in addition to that, we also offer free monthly webinars on various topics. We just did a webinar on Dynamex. We have another webinar coming up by our partner Todd Wolfson in the Orange County office that will cover the changes in California employment laws. So that would be another informative webinar for people to attend. But yes, to your initial question, we regularly counsel employers, and in fact, we have some people at the firm who are devoted to just doing that, who do not litigate cases, but who rather spend their time advising employers so that they can avoid litigation. And those people are very helpful to employers because, the goal is to avoid litigation to begin with. However, if you cannot avoid litigation for whatever reason, then we are here to help you through that litigation process. But ultimately, the goal is for us to work with our clients to ensure that they are complying with California employment law.
Yeah, good. Well, let me just second that recommendation regarding your blog. I actually, get that blog, and it's very helpful. And we'll post, details about how to subscribe to the when we post this video, and we'll try to add a card at the end of the video to direct people to where they can do that. But thanks for the background. And as someone that works every day with companies, the challenge of complying with existing California laws around employment, and then not only that, but keeping up with the changes, just within the state, and then, as you say, like county by county and city by city, and add to that the kind of patchwork when people have multi-state operations, and it's really quite amazing, and in not a good way as to how demanding it can be to comply with law, even when you have the best intentions about being fully in compliance. Sometimes it's just difficult to understand how to navigate it correctly. So that's why I'm thrilled to be here with you, Dawn, because clients need expertise in this area. So with that as a launching point, let's talk about the process of letting employees go. And it's such a fraught process, I think, in part because almost always in the background is this looming possibility that when I'm letting someone go, I'm going to get sued for doing something wrong. And what I want to do, my real goal here, is to help employers understand the key risk points, like what in your experience are the key risk factors that signal that a termination is likely to be problematic, right? So what should we be on the lookout for? And then two, like, how do you mitigate, address, and ideally eliminate those risk factors in a termination? So I, to the extent that that's possible, right? So I don't know if do those questions make sense, Dawn?
They do. And I'm going to sort of start with the premise that you have an employee who you're contemplating a termination for. And I think it's really important from the start that the decision maker thinks about, okay, so why am I terminating this employee? In most cases, it's because of performance. And when you have a situation where you have an underperforming employee, what's really important for you to ask yourself, and then frankly to have a neutral person then follow up and ask these questions, is, okay, have I clearly communicated to this employee the expectations of the job? And Francesco, as I'm sure you can imagine, in my world, almost always when I ask that question, the answer is, of course. And then I say, okay, what have, and then that's where things get a little tricky. So when someone is asking you, or you're asking yourself, have I clearly communicated these expectations to this employee, you have to ask yourself, how did I communicate that? Did I communicate it verbally? Did I communicate it in writing? And written form is always the best form. So if you have a job description that was presented to the employee at the outset of her employment, did they sign it, sign an acknowledgement of receipt? Do you have performance evaluations where there are certain metrics that are outlined? Did you give clear feedback to the employee about how she or he performed with respect to those metrics? Did the employee acknowledge receipt of that feedback? Have you provided any, verbal or written warnings to the employee? If you have provided such warnings, did they acknowledge receipt of those warnings? And what I have found, where a lot of employers sometimes run into trouble, is when there's an otherwise facially neutral email. They're saying, well, they know based on that. It's some sort of passive-aggressive communication where, based on that, they should have known that I was not happy with their performance. So what you really need to ask yourself is, if some neutral person comes in who does not know anything about what you do, reading this, could they discern from that email that you are giving clear feedback to the employee of a performance deficiency? And so I think the first step is to always look at, why am I making this decision, and do I have documented support for the decision that I'm making? Then it's really important to then consider, okay, so again, it's performance. How have I handled a similar situation in the past? And that could go for performance, and that could go for policy violations. It's really important to say to yourself, and to have, frankly, a neutral person question you as to whether or not you are treating this particular employee the same way you have treated other similarly situated employees, meaning other employees who have engaged in either the same bad behavior or who have had similar performance issues. Are you treating them all the same way? And if the answer to those questions is yes, then I think employers need to further consider, has this employee in the last year or 6 months or some period of time, has this employee engaged in any protected activity? That's what lawyers call a term of art that really speaks to whether they have complained about anything, any workplace issues, whether they feel their supervisor is treating them unfairly because, they are of a specific race or gender or whatever, or just being mean to them for some unknown reason. Have they complained about the operations in some way? If you're dealing with a healthcare organization, have they made any complaints about billing issues or patient care issues? If it's a retail establishment, have they talked about, false advertising, advertising for one price, and then when the customer comes in, you only have one item for that price, yet all these other items are, 50% higher in price, something along those lines. And then the other protected activity that a lot of employers either don't consider or don't fully consider is whether someone has, within the past year, I would say, requested some sort of medical leave or accommodation and or indicated or disclosed that they suffer from a medical condition that might in the future require some form of accommodation, potentially in the form of leave. And why I think that's probably particularly important for many entrepreneurs is because a lot of entrepreneurs don't have a lot of employees. And so when one employee gives them any sort of heads up that, hey, I've got this heart condition that may require that I have, surgery or may require some, time off, or I have, hip issues and I might need hip replacement and the recovery period is 6 weeks to, 3 months or whatever the case may be, they kind of freak out and they think, oh my God, I don't know if I can deal with that. But here's the thing, it's a separate issue from performance. So if someone comes to you today and says, hey, my doctor's telling me that, unless there's some significant change in my condition, I'm going to have my knees replaced. And that will take me out of commission for 2 months. And then next week, all of a sudden, this same employee who previously had, positive performance reviews is getting negative feedback about his or her performance. That's going to be problematic just from a timing perspective, because the employee, assuming the employer, is subject to FEHA, which is 5 or more employees in the state of California, the employee has put the employer on notice that he or she suffers from some condition that might require some form of accommodation in the future, and they can state a claim for perceived disability. And if the employer all of a sudden starts, writing this person up or giving verbal feedback that's negative, it could create a very difficult situation. So I think when an employer is looking to terminate someone, they really need to consider all of these things. One, what am I looking at here in terms of the basis for term? 2, what documentation do I have to support it? 3, how have I treated other people in the past who've engaged in the same conduct or have similar performance issues? And then lastly, has this employee engaged in any protected activity within the last 6 months to a year? Now, that's not to say they shouldn't terminate the employee if they have engaged in protected activity. It's just that's something they need to be aware of from a risk perspective.
Yeah. I mean, in terms of these are the what you've identified are the especially with respect to the protected activity, like complaints where there's a potential basis for a claim of retaliation or discrimination based on that protected activity, the taking of medical leave, injuries and disabilities. Those are obviously areas where employees have heightened protections under the law. And so, and the nature of those protections and the nature of employers' obligations in those scenarios can be really complex. And those are areas where, expert guidance, I would say, is of paramount importance. Another thing that I heard you saying really with respect to the documentation, in many cases, my clients do not yet have in place a systematized, calendared, regular performance appraisal mechanism, and so the nature of the documentation is like you suggested. It's an email exchange, and it's not a systematic and regular and repeated performance appraisal process where there's a documented evaluation of performance and feedback and so forth. So then and what will happen is the performance issues will have been brewing for some period of time, even though they're not documented. And then there's this urgency to let somebody go. And there's no, and let's say the employee it's an at-will employment relationship. And so it's kind of baffling, I think, to think like, why can't I just let this at-will, I mean, the performance issues are there. It's not a satisfactory situation from my standpoint, and okay, the documentation isn't perfect, but, is that really, why is that even relevant in an at-will employment relationship?
For a few reasons. You can terminate an employee in the state of California pursuant to 2922, they're at will, for any reason or no reason at all, as long as it's not an unlawful reason. So in California, there are many protections for employees, as you know. And so this discussion is really focused around how you can mitigate the potential of a lawsuit based on your termination decision. And so what I see in my world, because I'm a litigator, is you have an employee who is at will, most are. I have some employers who are for-cause employers, but putting that aside, they're at will, they show up late every day, they leave early, they're surfing the web when they should be working, they've got a myriad of performance issues, and the manager says, I'm done. I'm not gonna deal with this, and I'm gonna terminate this employee. And nothing wrong with that, absolutely. But if you don't have the documentation to support that decision, then the employee can say, well, no, this supervisor, male supervisor, I'm the only female on his team. The guy that sits next to me, he shows up late, he leaves early, he's surfing the web, he's ordering things online, and I think my performance is just as good, if not better, than his. And so the only reason why my supervisor is targeting me is because I'm a woman. And oh, by the way, he didn't hire me. Somebody else did, a woman. And she was fired by some other guy. And so here, you're going to have a situation where the employee can say whatever he or she wants to say. And so if they do have to have evidence, and the evidence could be in the form of testimony. Like, these are the things that happen. And a prima facie burden in the state of California, which is the burden that you have to establish in order to survive a summary judgment motion, is pretty low. And if you're talking about summary judgment, if you're talking about, trying to get a case dismissed on summary judgment, you're talking tens of thousands of dollars in litigation fees, not to mention the time to take depositions, to investigate the claims internally, the disruption to your business. And if you're talking about a relatively new employer or a startup, that could put them out of business. One litigation can put them out of business. And I've seen, unfortunately, that happen more than once. So the reality is it's important for your business to make sure that you get it right and that you have this documentation. It doesn't need to be formal, though, Francesco, in terms of, it doesn't have to be this beautiful form that you pay an attorney tens of thousands of dollars to create. It just does, it needs to be very clear in that, okay, so as whatever your job is, you are expected to primarily focus on these things. And your monthly goals are X. And during the month of May, this is how you performed. And this is how you fell short of that performance. And this is what I expect to see going forward. And so that could be in an email, or a better approach, in my opinion, is to have something typed up in an outline format, have a discussion with the employee based on those points, and then send a summarizing email saying, as we discussed earlier today, these are the issues of concern, yada, yada, yada. Going forward, I'm hopeful that you turn these things around so that, because the goal really is that if there is a performance issue, that they correct it, right? And nobody wants to fire somebody because that is unpleasant. It's an unpleasant situation.
And in speaking to you, I mean, it's so clear how valuable it is to have a regular process like that in place, established at a time when it's not needed. Like, so it's a neutrally established and equally applied process of giving people feedback, the opportunity to understand the expectations around them and satisfy them and improve their performance. And that makes a lot of sense. Now, in the in terms of the protected activities you mentioned, I've been in that situation before in terms of representing companies that they have these problematic employees, and the issue is, part of what makes them problematic is that they're these complainers. And then, or maybe they have, I don't mean to downplay some of the complaints and so forth, but I have seen that situation, where you have a problematic employee that is making all kinds of complaints regarding the alleged motive of their supervisor, and so forth, right? And so, can you share a little bit about, how to navigate? What is the best way to navigate a situation where you have a protected activity, and you nevertheless, you need to, well, let's just say you have a protected, what may be a protected activity in the context of a really problematic employee.
Yeah. So, that comes up a lot, because then you have protected activity, and frankly, what I see a lot of is you have an employee who is not performing well. And either the employee sees the writing on the wall because you've given them the feedback that I keep saying you need to give them, and they then sort of hold up this sword or a shield and say, I want to be insulated from any potential termination based on my performance, so I'm going to complain about this and attribute some illegal motive to the feedback that I'm getting. And so then managers often do not know how to maneuver around that, because then they feel that they're now being tried in the court of public opinion. But here's what needs to happen. Regardless of whether the employee complains once, twice, or 10,000 times, you need to investigate. You need to listen. Somebody needs to listen, and hopefully the employer is big enough that if they're complaining about the supervisor, there's somebody else they can speak to, hopefully an HR representative, because that's what they're there for. They're supposed to be a neutral, in-house person who can look at the policies, who can listen to the complaints of the employee, who maybe has a broader perspective in how the company typically handles situations, and can interview relevant individuals who have information about the claims being made. So if, for example, all the time you hear things like, so-and-so told me that they have never been written at before, for whatever it is, coming in late. And, the HR person has access to that other person's personnel files, or can speak to the manager and say, hey, did you write that person for the same thing? I understand that he or she engaged in the same conduct. So the most important thing to do when you receive a complaint is to investigate it, even if that complaint comes in on the day of termination. So if you're sitting there in a termination meeting and there should be two people present, the decision maker and a neutral person, either someone from HR, if you don't have HR, maybe a manager of another group that doesn't supervise plaintiffs. So someone should be taking notes and looking at any issues that are raised. And if someone says, you know, either in a termination meeting or before a termination meeting, you know, I feel that I'm being treated unfairly because I'm a woman, or because I'm over 40, or because of my race, or because I now have a medical condition that I disclosed to my supervisor, and they keep talking about what a burden I'm going to become because, you know, they need to get sales in this region and they can't get sales if they don't have coverage, whatever. They need to look into that. And so that can be challenging for a startup when they don't have a significant number of resources, but it does need to happen. And if there are witnesses or other employees who are interviewed and they provide information during that interview, it would be better to get a statement from them. If it's a situation where something happens that people observe, it's a harassment claim, and they said there was a meeting, and during that meeting, the supervisor said disparaging remarks based on my gender. Who was at that meeting? Who can corroborate or substantiate what you're saying? And if they identify 3 people and somebody speaks to those 3 people, and those 3 people say, I didn't hear anything like that, you know, statements should be obtained, good or bad, frankly. And so
what I'm hearing, Dawn, is you're saying,
to do. I'm sorry, what was that?
Yeah, I'm sorry, I think your audio broke up a bit.
Yeah. Oh, can you hear me now?
Yes, yeah. So what you're saying is, you know, when you have an allegation that is, you know, obviously a serious one with potential legal consequences, really, it's very significant to take it. It's important to take it seriously and to get to the bottom of it and to demonstrate to others that you've gotten to the bottom of it. And do you recommend that occur prior to any termination decision is finalized?
I think so. And I think during that interview process, I think people need to also, and I mean, we're lawyers, so we know how to question people. But if you're dealing with someone who's saying things that were like, I don't think my manager likes me. And the normal follow-up would be, why do you feel that way? Why is it that you feel that he or she does not like you? Because you want to know if they believe it's based on some protected reason, or if they just think their manager just doesn't like him or her, or just because they, you know, they don't like the color of their shirt, or you know, their personalities don't jive, or maybe they don't like the fact that you're not doing your job very well. You know, so it's important to sort of like, why do they feel that way? To find out if there's any there, you know, if there's anything to be concerned about, as opposed to they just get the sense that, you know, my manager doesn't like me, and usually if they think the manager doesn't like him or her, they think they like someone better. And why do you think they like that person better? What have they said or done to lead you to believe that? And have you had performance issues?
Yeah, so I mean, you know, it's interesting because you're having this conversation in the context of you're about to let somebody go, and the employee is saying this, that, and the other thing are going on. And part of what I hear you saying, Dawn, is that it's important in this context to essentially to understand if there are grievances that even if the employee is not articulating them particularly well, that it's valuable to understand if there are grievances going on sort of behind the scenes, and if so, what are they, and are you comfortable that there's no basis to them? Like, have you done sufficient diligence and investigation?
Yeah, just to clarify, what I was contemplating really when we were talking about grievances, because you have these complaining employees, is really before you get to the termination decision. And so when you're looking back over the documents, you really want to be able to say, okay, yes, this employee did raise issues, but we investigated those issues and we reached these conclusions. So
that's helpful. Yeah, so it's like pointing back again to the importance of having these opportunities for dialogue and performance appraisals and kind of a mutual evaluation of what's going on, so that issues can be surfaced and dealt with and documented in real time.
Yeah. And that kind of goes hand in hand with, I guess, a potential pitfall. And one of the key pitfalls, I would say, when separating an employee is that employers often, I don't want to say they make a rush to judgment, but once they decide, they're in a rush, and they don't sit back and sort of look at all the documentation, and they don't think about, okay, how have we treated other employees who have engaged in the same conduct? They sort of, it's unpleasant, so they want to get through it, so to speak. But it's really important to kind of slow down, think about what's happening, think about why you're doing what you're doing, because it's a serious decision to make, and then make sure that if these issues have come up, meaning they've complained in the past and, you know, all of this stuff has happened, that you can say, but we looked into that, and here's all the documentation that we have demonstrating that we looked into that, and there was no there with respect to those claims. Now, if an employee raises a complaint during the termination meeting, hopefully you can say to yourself at least, okay, these are things that we've already looked into.
You're right.
They raise
Yeah.
information, then you take that down, and if it's something that, you know, you're saying, well, that would have changed the outcome, you need to look at it. But it doesn't mean that you're going to say, oh, okay, wait, no termination. We're gonna pause everything. You know, you do need to, if they tell you something that you had not been aware of in the past, then, you know, try to think about, okay, from a business perspective, if that's really true, that's concerning, and then look into it and see what's going on. One of the things that we haven't spoken about that I think, because I know we're probably running out of time, but if you do identify an employee where you think there might be some concern that they may sue, and why would you think that? It could be that there are performance issues, that they become defensive, that they've requested that you send them their records or make them available to them. Those are some red flags that you should look out for. I think as part of the slowdown and think about what you're doing, I think you should also think about, does it make sense to offer them some form of severance that you would not otherwise offer to them in exchange for a release of claims. And so that way, you can separate the employee, you can both move forward and not worry about any potential lawsuits. And I have a lot of employers that do that, not because they feel they've done anything wrong, it's just that they want to have some assurance that they're not going to see this person, you know, on the other side of the table at some form of litigation. So that's something to consider. And if you go that route, you absolutely should consult with an attorney to ensure that your separation agreement, your release, is enforceable under California law. And because you don't want to pay consideration, get this signed release, and then have someone challenge it and say it's not enforceable. And that area of the law has changed somewhat in light of the Me Too movement. What can be released, what you can say in terms of non-disparagement, things like that. So you really do need to consult with counsel if you identify an employee where you think this employee should be terminated, but we have some concerns that they might try and sue us.
Yeah, that's good. That's valuable. And I was going to ask about the severance and the offering. Do you have any tips in terms of how to present severance and the release of claims? Like, what's the most effective way to do that?
Well, during the termination meeting, there should be two people there from the company. The neutral person should say, we know that separating an employee is difficult in terms of for the employee as well, because they have to go and find a job. And so to help bridge that gap, we are willing to offer you whatever in the form of severance in exchange for a signed release. You present them, have the release there, tell them they can take it and consider it. They can consult with their own counsel if they wish to do so, and ask them to, get back to you by a date certain. And so that way, it's all sort of handled in one sitting. Now, they will probably do is take that release and go to an attorney, and you may get a call from an attorney who's going to try and add value and negotiate something higher. So part of your deliberative process in terms of offering severance should be, is this a take it or leave it, or are we going to negotiate with somebody else, and if so, what would we consider? And sometimes you can do that beforehand, sometimes not, because sometimes the attorneys will send you some information that you either didn't know about, or they've massaged the facts in a way that are not entirely accurate, that they're trying to cast it in a light that's most favorable to the client, so that if they do sue, they have some sort of a claim.
Super. Okay. Well, Dawn, listen, thank you so much. This was a very illuminating and helpful conversation. I think a lot of, I know my clients and a lot of other business owners and entrepreneurs out there are going to be going to find this very valuable. I feel like I could talk about it for another hour, but our time is up. But yeah, it was a pleasure speaking with you, Dawn, as always, and yeah, thank you again.
You're very welcome. I had fun.
Okay. All right. Thank you. Till next time.